it is the standard is very low. The standard under Delaware law is basically as long as the board sees that there is some kind of program in place, and that management has put some kind of program in place, the board is satisfied their duty at that point.
Yeah.
And unless they are really willfully turning a blind eye, then they're deemed to have fulfilled their duty. Now, they may have not done it well, but they did it, and then they're absolved of liability. And so, so that to me, that's the basic problem, that the legal standard is so low, that, in terms of the lawyers who advise the boards, they basically tell them, you pretty much have to try to fall down on the job. And I think that leaves the board with too much of this sense of security, and allows them to get very lazy and complacent. And management has a way of kind of gradually rationalizing decisions to make them look okay and make people feel okay over time. And it's very hard for the board. It takes a lot of fortitude for a board member to stand up and say, no, this is, don't stand here and tell me that this is okay.
Yeah.
And the culture of boards are not such that one individual, is going to feel free to do that.
Right. That's it. That's interesting. Very interesting.
For a board, it does take, one individual to start the discussion, and you usually don't have that individual, even if these people are great business people, and the idea that the board needs to act in concert and in kind of this unanimous manner, or on a consensus basis. Every director, just their senses tell them that, all right, if I raise this, we might not reach consensus. It might turn into a real situation. Then they'll keep it to themselves, or they might raise it with the chair, and then they and the chair will make some kind of decision on how they handle it. And the preferred way to handle things is to do it in a very quiet manner.
Yeah.
And not say, okay, this is a board issue, we have to put it on the agenda for next time. The way to handle it is, okay, look, we'll have a discussion with the CEO and mention it, and then we will have done our jobs. In terms of the board role of compliance, I'd say it's lacking because of the natural pressures, that at least in terms of governance and business practices in the United States, kind of what's formed over time in terms of the norms.
Because is there much out there, Doug, in terms of how would you say it? Is there lessons in the public arena in terms of individual board members being prosecuted? Like something that is an incentive to do the right thing or speak up or turn against the tide, where decisions are not being made?
It is extremely rare in terms of the legal cases.
Yeah.
In terms of boards being found liable, this is very rare.
Okay.
Enron was, I think, the only case where the board members ended up paying out of their own pockets.
Right.
All the other cases you had insurance picking up the tab,
yes, yeah.
or the board basically, being slapped on the wrist for, being kind of scolded by the judge for only doing the bare minimum.
Mm-hmm.
Disney, the Disney cases, with Eisner and, Ovitz, the Michael Ovitz hiring and firing decisions.
Yeah.
Those were cases where the opinions basically say, look, this was very, very shady what you guys did. But by the legal standards, you did fulfill what you're supposed to do. But they even said by what's evolved and by the standards of today, which is when, the standards of when the decisions were made, the court decisions were made, by the standards that had evolved, they probably would not have passed those standards. And, I think the courts unfortunately do not have much of a deterrent effect, mm-hmm. the court cases. Mm-hmm. It's, at this point, it's really the court of public opinion, that is the biggest deterrence. And I don't even think it's, the investor community has some effect, but, the way these people think, it's all about stock price.
Yeah, yeah.
Look, if this came out and the stock price didn't go down, then we could just breathe a sigh of relief. Or even if, we're going to litigation and there's a possibility of a huge, judgment, if we set aside a reserve and the investors are okay with that, then we can breathe a sigh of relief.
Yeah.
I've seen that over and over again. But when you have the media or the government really coming down hard and creating a lot of bad publicity, that's when, that's the disincentive. And so, as the lawyer in the room, oftentimes you're saying, look, what you're going to do is perfectly legal, but, reputationally, mm-hmm. this is going to be a disaster.
Yeah.
This is going to be a big PR disaster. I always bring up the example of Senator Elizabeth Warren.
Yes, yeah.
And I'm not a huge fan of hers, but I tell people, look, you make this decision, are you going to be able to pass the Elizabeth Warren test, which is if you are sitting at a table in Congress at a subcommittee meeting and she is yelling at you and accusing you of being a criminal and saying you should be fired, are you going to be okay with that?
Yeah.
How are you going to handle that?
Yeah.
And so, to me, that's played out several times, and and sometimes she's been totally overboard, and melodramatic. Mm-hmm. But it was effective. Those executives ended up having to go away.
Yeah.
Wells Fargo is a good example.
I think it's an example that probably 9 out of 10 people I've spoken to have recalled.
Yeah, exactly. It's the most recent example. Yeah.
Yeah, and it echoes sort of what's happening back home in Australia. But I guess it goes back to that question, Doug, like it's often said that, the law lags behind what we as a society expect to be good ethical practice or, doing the right thing. So how do we hold then executives and boards and companies accountable for good corporate conduct?
The only way to do it is by external pressures. It's really the investment community and, the media and the regulators. They're the ones who are able to apply some kind of pressures that act as a disincentive.
Yeah.
Yeah, and I see that as a real problem. I mean, I think the law